So, good evening, Anuji, to our AYUSHMAN learning series. And we are grateful that I think we are getting you for the third time. So, we can't hear you, sir.
Muted.
Okay. Okay now? Can you hear me now?
Yeah,
Yes,
yeah,
I
I
can
can
hear
hear you,
you.
sir.
Okay.
So, but I think the volume is a bit low.
Your voice is echoing.
Oh,
Yes.
let me see.
Am I audible without an
You're
echo?
audible, but the volume is a bit low.
My seat is low.
Yes.
I need to go up. Should I increase my chair's height?
No, maybe he has me to say a voice bit muffled.
Is it okay now? Is it better now? Abhijit, is the voice okay now?
I think you need to put the microphone a bit away from your mouth. It's a bit,
Okay, now is it okay now?
it's better. Yeah, yeah, it's better. Yeah.
Okay, so I need to have space.
Yes, sir. I think it's better now.
Is it okay now?
Yes, a bit better.
Is it fine?
Right, sir.
Okay, good.
Good evening, everyone. And we are grateful to have with us Anilji from Punjab. He's a specialized legal expert in custody of cases and matrimonial rules. And we are happy that we are getting him for the third time, I think, in the morning Ayushman series. The first, we had a webinar with him, I think, a couple of years back. And then he was kind enough to join us in one of our seminars which we had held virtually uh, on the child protection law. And now we are having an interaction with him to share his thoughts on child custody matters, but related to a specific Calcutta High Court order which had come out a few days back. And I was very much surprised, but I was very happy to know that a discussion on this specific order was published in one of the papers which he forwarded to me, and which I think heard in the group today morning. And there was a very interesting update on the analysis of the Calcutta High Court order. Now, why we have chosen this discussion on this particular order is because of the fact that an analysis of the same from the applicant point of view, we found that in this particular case,
Thank you, Arijit. It's wonderful talking to your organization and all the respected fellow members who have joined in aggrieved parents, lawyers, jurists, and other people who are affected and aggrieved by this. Arijit, before I start, I go back to William Wordsworth. William Wordsworth used the expression, the child is the father of man, in his poem in 1802. And the poem was called The Heart Leaps Up. It was also known as the Rainbow. Now, listen to what William Wordsworth said in 1802. It is a perfect pronouncement in the judgment of what is said in the poem. It says, my heart leaps up when I behold a rainbow in the sky. So was it when my life began. So is it now I am a man. So be it when I shall grow old, or let me die. The child is the father of man, and I wish I could my days to be bound each to each by natural pity. So this is a very deep meaning thought, which I think is the cry of the child, is the voice of the child. The voice of the child has to find a meaningful expression in any child custody litigation. The Hindu Minority and Guardianship Act and the Guardian and Wards Act both say that in any issue relating to guardianship, custody, the best interest and the welfare of the child shall be the paramount consideration. Now, this expression, the best interest of the child, is not defined in any legislation of the Hindu Acts or the Guardian and Wards Act. But after India signed the United Nations Convention on the Rights of the Child, the expression best interest of the child has found an expression, a meaning, a definition. It says best interest of the child means the basis for any decision taken regarding the child to ensure fulfillment of its basic rights, needs, identity, social well-being, and physical, emotional, and intellectual development. Now, before I really go into the judgment, let us see the backdrop of how this concept has come in law and how it crept in judgments of the Delhi High Court after I started arguing child custody matters in Delhi. Initially, when I urged this definition of the best interest of the child under Section 29 of the Juvenile Justice, Care and Protection of Children Act 2015, I was told by the bench that this is meant for juveniles in conflict with law, orphan, abandoned, or surrendered children. I said, no, it is meant for the child. And the child's welfare has been incorporated in this act after India signed the United Nations Convention on the Rights of the Child. Now, India signed this convention in 1989, sorry, 1992, and under this convention, it was said in the preamble, convinced that the family as the fundamental group of society and the natural environment for the growth and well-being of all its members, and particularly children, should be afforded necessary protection and assistance so that it can assume full responsibility within the community, recognizing that the child, for the full and harmonious development of his or her personality, should grow up in a family environment in an atmosphere of happiness, love, and understanding. I pause here. I never forget Justice Mridula Bhatkar's coin in a judgment describing what is a family. What is family? Father and mother, I love you. Family. Each of these words have been said to be a meaning And how beautifully put. So once we signed this convention, it was also said, bearing in mind, as indicated in the Declaration of the Rights of the child, by reason of his physical and mental maturity, needs special safeguards and care, including appropriate legal profession after the birth. So, recognizing the importance of international cooperation by improving the living conditions of children in every country, all people agree as follows. Now, Article 6 is very important. It says state parties must recognize that every child has an inherent right to life. So, listeners, the inherent right of the child to life means the voice of the child. The child, as we say in Article 21, right to life. So, the right to life has been incorporated in the UNCRC and it has come in the JJ Act. Now, Article 8 says that every state shall undertake that the right to child has a right identity, nationality, name, family relations, and every country shall endeavor to put the child back if he is separated from his parents. Now, in this regard, Article says state parties shall ensure that the child is not separated from his or her parents against their will, except in accordance with a process subject to judicial review. And if the parents are living separately, a decision must be made as to the child's place of residence. Now, these are principles which we have incorporated from the UNCRC. Then, most important, what I think, if I was assisting the court in Calcutta, I think Justice Somen Sen and Justice Uday Kumar have done a wonderful job in this judgment of 28th of February 23. Now, where does this come from? It comes from Article 12 of the UNCRC. It's Article 12 says, state parties shall assure to the child who is capable of forming his or her own views the right to express those views freely in all matters affecting the child, the views of the child being given due weightage in accordance with the age and maturity of the child. Article 12(2). For this purpose, the child shall in particular be provided the opportunity to be heard in any judicial and administrative proceedings affecting the child, either directly or through a representative or an appropriate body, in a manner consistent with the procedural rules of national law. So we have very happily picked up this. We have acceded to the convention. We have signed this convention. But what have we done to have the voice of the child incorporated in our legislation? In the Juvenile Justice Act, we have not done anything. But luckily and happily, the antique Guardian and Wards Act of 1890, there was, though this act has outlived its utility, but I would still think that in Article 17, subsection 3, where the court talks of matters to be considered by the court in appointing the guardian. So 17(1) says, in appointing or declaring a guardian, the court shall, subject to the section, be guided by consistently what is the law to which the provider appears to be in the circumstances for the welfare of the minor. Then subsection 2, what is the welfare? Court shall have regards to the sex, age, religion, character, and so and so. But 17(3), if the minor is old enough to form an intelligent preference, the court may consider that preference. The court may. It doesn't say the court shall. So there is a discretion of the court to consider the voice of the child. But I think Article 12 of the UNCRC has brought forth the voice of the child in a very powerful and a very potent way. And it has left no margin to do this. Now, initially, we were guided by the Guardian and Wards Act, but with the coming in of the Family Courts Act 1984, now we all forget that the Family Courts Act 1984, in which matters relating to under Section 7 are regarding marriage, regarding property, regarding circumstances of a relationship, legitimacy of children, or a suit or proceeding for guardianship or custody over access to the minor. What is the fundamental underlying principle of the litigation? I think both honorable judges in the family courts and the lawyers, to a great extent, in a large, I don't say that it's everywhere, in a large proportion of the family courts, forget that the act is meant to promote conciliation and secure speedy settlement of disputes relating to marriage and family affairs and of matters connected herewith. I pause. When you deal with children, you have to have a degree of sensitivity. When you look at children, you don't start looking at who is a better parent. You should look at how you are going to put both the parents to the child to bring him up as a normal child. So, for this purpose, there is so much flexibility which the Court Act has given. In Section 10, first of all, in Section 9, the court has to make an effort of a settlement. And I think Murali ma'am will bear me out. In that respect, Mumbai has done the most advanced thing. It has selected a panel of lawyers and has officially notified them as child independent lawyers. So the child has a voice, the child has a lawyer. And that child independent lawyer is a neutral person who tells the left and the right, this is not a divorce petition, this is the child, please get aside. So this is one development which I think every family court in the country should emulate for the voice of the child. This is one very positive thing. Then Section 10, procedurally, CPC applies, but it says nothing in this section shall prevent a family court from laying down its own procedure with a view to arrive at a settlement in respect of the subject matter or the truth of the facts alleged by one party and denied by the other. And for this purpose, Section 14 says Evidence Act can be given a go by. By how? It says the family court may receive in evidence any report, statement, document, information which in its opinion is necessary to deal effectually a dispute whether the same would be admissible in evidence or not. So there is no need to go into formality of law. I think we all need to go down to the psychology of the act and start looking at children, dehorse the parents, and deciding cases on the welfare of the child. The Guardian and Wards Act, I think, is a square peg in a round hole. By the singular concept of custody, it promotes lies, fabrication of truth, all murky allegations in trying to prove I'm a better parent. And in that process, both the lawyers and the court lose track of the fact that this is not a fight to award a trophy. Actually, the person who gets the child is the loser, in my view, because the child has lost out to the other parent. And what are we promoting? We are promoting alienation. We are not even noticing it. And day in and day out, the courts are going in the direction of what statute says. It's high time report number 257 of Justice A.P. Shah of 2015 is brought forth. The HMGA is amended, the GWA is amended, joint parenting, shared custody concept should be brought forth. There is now an explosion of litigation. And with these conventional methods with which we proceed, adjournments, delays, parents who are left out of custody are turning into nervous wrecks. And they have started doing things like kidnapping children. They have started taking law into their own hands, and it's disaster. I don't blame a parent who does it because he loves his child, but he breaks the law. So law doesn't forgive him. And if a judge tells me what's wrong, I say what he has done is wrong, but there is a justification. But does the justification serve the purpose? The answer is yet to be decided. Now, the family court has got a lot of flexibility of taking the help of medical and welfare experts. This is something I think we family courts seriously need to do. In Delhi, in all the family courts, T. Cesari, Karkadoma, Patala House, Saket, there is a separate building of the family court. There is a counselor, there is a principal family judge, and there is a regime of all the infrastructure in the court. So what is it? Now this is, in any suit or proceeding, a family court can secure a medical expert or such person, whether related to the parties or not, including a person professionally engaged in promoting the welfare of the children, for the purpose of assisting the family court in discharging the functions. I think most cases of child custody need a child psychologist, or it needs a specialist with studies of psychiatry. We are fortunate in Chandigarh, we have the PGI MER, and in our mediation room also, we have two mediators who are trained in counseling issues. So these kind of people, I think, are becoming necessary for this purpose. Then there is the provision of the court to take legal representation. That is, of course, lawyers can appear, but then it is also said that the court, in the interest of justice, can take the legal expert as amicus curiae. Now, this is something which the courts need to do. When the court thinks it's too murky, I do amicus work in child abduction matters, and before the judge is a 2,000-page paper book, and not a word of it relates to the child. It's all about surveillance videos, visiting hotels with XYZ, beating the child, molesting the child, heaping cruelty on the man or the woman. So the invariably, I have often seen a judge saying, I am going to send the child to a boarding school. None of you deserve the custody. What is to be done? So the the custody petition has become a divorce petition. And unfortunately, most courts, copy pasting is done. The divorce petition is copy pasted, top and bottom is changed, and that becomes the custody petition. And there is not a word about the child. And unfortunately, the courts also get lost into that direction, and issues are coined on the basis of pleadings. Pleadings are based on statute. So we are going south if instead of going north. But then, now with this background, let us come to what has happened. I shared with Arijit a very good write up in the Indian Express today about a layperson saying this judgment has silently brought in father's guardianship, father's custody, based on the voice of the child, based on the view of the child. Now, as Arijit said, the child was miserable. Mother was a teacher. She was never there. His grandparents were there, but they were a little away. They would visit him. There was nothing in common. He was bored. He came home. But then his father's family, he had cousins, he had siblings, he had grandparents, and he had a joint family setup. And the boy, 13-year-old boy, was very clear. I think some paragraphs of the judgment are worth reading, and I will read them out because this judgment is a change of jurisprudence on the best interest of the child. Now, in Lahari Sakhamuri and in Yashita Sahu, the Supreme Court has clearly come out to say gender preference is out. So, if somebody says under Section 6 of the Hindu Minority and Guardianship Act, I am the mother, the child is less than 5 years of age, I have a right to the custody, that concept has been watered down. It has been watered down by the Supreme Court. But the inherent feeling of a court or a judge in his personal perception that the child less than 5 years of age should be with the mother in my humble view, influences the judge to give the child to the mother. Not he just thinks that way. It's a personal perception. It is not a logical perception on the analysis of the child. Now, Lahari Sakhamuri and Justice, I I'm forgetting the name of the honorable judge. Now, he was very clear. He says nothing, it's apt in no uncertain terms. And we go back to Neil Ratan Kundu. Boy was over 11. Father had been convicted for murdering his wife. And the boy says, I want to live with my grandparents. And the Supreme Court says, you go with the grandparents. Now, that is the best interest of the child. You do not decide on genetics. You do not decide whose genes the child has got. You decide on the welfare of the child. So in this case, uh, the child spoke out, and there is a paragraph which I want to read. It says, the now this is uh, the judgment is, the parties is Sushmita Sarkar Mundal versus Pratik Ram Mundal, and this is FMA 1750 or 2018, and it is decided on 28th of February 2023. So this, first of all, what is it about? The appeal is arising out of a judgment passed in an application filed by Pratik Ram Mundal for custody of the ward under section so and so of the Garden Wards Act, with so and so and so and so. The application was filed for the restoration of custody of his minor son Priyanshu, who was alleged to have been illegally removed from the custody of the guardianship of Pratik Ram by his wife Sushmita on the 4th March 2017. So the child was with the father till 2017, and the father is wanting the child back to him in his custody. And for all lay persons, the conclusion is the child goes back to the father. I'll just read out the end part so that we know exactly what happened. Uh, they say the father's fitness to be the guardian, the love and affection of the grandparents for the minor, the environment and atmosphere of the father's place, the education and favorable surroundings at the said place, and above all, the physical and mental comfort of the child is likely to receive at the father's place, and the desire of the child has persuaded us to give custody of the minor to the father and affirm the order under appeal with modification. So it is so beautifully put. His welfare, his his uh, his choice. So it is not just the choice of the child. It is a mix. So let us read once again. The father's fitness to be the guardian, 1. Love and affection of the grandparents, 2. Environment and atmosphere of the father's place, 3. The educational and favorable surroundings of at the said place, 5. And all physical and mental comfort the child is likely to see the father's place, 6. And the desire of the child, 7. So yesterday we did a discussion on this topic. So somebody said, is the decision of the court only on the basis of the voice of the child right? Does it outweigh welfare? Does it outweigh evidence? No. We must understand section 17.3 says, if the minor is old enough to make an intelligent preference, the court may consider that choice. So first of all, the child's maturity, which the court has to judge, the court is well equipped. 2, it is one consideration. And 3, the court may, it is not that court shall. If the court comes to the view, as was the case in Vivek Singh versus Rumani Singh, Justice Sikri said, I am not going to decide anything. The child is very badly polarized. So in that case, even though the child was old enough and was expressing something, the court said, we will not consider it because the child is very heavily alienated and he is not speaking his true self. So all listeners, it's not just consent, it is a mix. And there are 7 factors which the court has identified. But the court was very considerate. They have given the custody to the father. With the respondent is fair. Appellant mother should meet her child uh, in Puja festival, winter vacation, take the son for a vacation, and mutually agree for 10 days, and so on and so forth. Now, I think that this judgment ought to have been tweaked a little. And this was where the judgment could have really gone forward. How and why? They should have brought in joint custody and shared parenting. They should have said father will be primary caretaker because the child likes the house, the child likes the school, the child likes the environment. So it is better for the child. But the mother is a school teacher. You must make her a joint custodian and give her a right of shared parenting. The boy has some problem in school. The mother must be allowed to go to the school for a PTM. Now here, father will write a letter. Mother cannot go to school. School will say, please don't come. Now an important decision is to be taken, let us say, for some medical problem. The father should talk to the mother and say, this is what I'm going to do. What do you say? So there is some holiday, there is some vaccination, there is some event in the family, there is some trip abroad. So I think after having said all this, if the court would have said we we direct joint custody, shared parenting, we let the primary custody and caregiver be the father, and flexibility to the mother to go over on weekends or on whenever the child wants to go, or they should have devised some plan. This is what I think ought to have been done. Now, the child in this case, I think, this is my view, will start speaking for the father, and he will start speaking in the voice of the father, and maybe, this is my perception, may start feeling have ill will against the mother. This is wrong. This is not going to do justice to the child. I think this is where the judgment has gone wrong. It, after having done so much, if the court had swerved the path into a joint parenting and shared custody with a timetable, as we see in so many cases of like Savita Sitaram, then these judgments are very, in fact, these judgments on this point are very good. The Let me just point out, Yashita Sahu, Deepak Gupta judge says, child goes back to USA, mother may go, she may not go, it's up to her. But if she goes, she's welcome. She can take a divorce or go back. Same thing happened in Navteej Singh. Now, Savita Sitaram, wonderful judgment on parenting plan. Tushar Vishnu Bale, Bombay, 2016, excellent. Then Inderbir Singh, Amandeep Bands is the case I did. Senior police officer, father, mother a PhD, a lecturer. Monday to Friday, father. Monday to Friday, mother. In school, mother. Saturday, Sunday, father. The boy loves both his parents. The boy is very comfortable with both of them. Then our High Court is looking into Rajneesh Sharma and Kamal Kumar. They are asking the government to for sure joint parenting plan and shared custody. Then Aditi Bhatt versus Abhishek Ahuja, Delhi. Again, a shared parenting, joint custody. So I think it is time that we brought in something which is normal. Something we should not keep beating the abnormal path. Now, let us say what the court said when it awarded custody to the father. The contention of the wife that the child was duly taken care of her present residence is completely belied by the candid statement of the child that sometimes during weekends the maternal grandparents used to come and give company, but due to distance in old age, the visits were infrequent. The opposite party in cross-examination admitted that the child was suffering from ailments and she did not harm the father. Then the child could not be turned into a virtual recluse as it would likely cause psychological and physical disorder. The appellant father would overwhelmingly show that in his house, the child had all the facilities which would enable him to grow into a proper human being. When a joint family, for reasons now has declined and fragmented, it is better that the child has a better view. The child has also admitted in his brief interaction that he was extremely happy at his father's place in Balurghat. The child did not complain of any rude behavior with the father. Creation of any unwanted situation in order to separate the child from the father should not be condoned or encouraged just because the applicant is the mother of the child. We do not find any justification of the child from Techno India to comparative school at Balarghat and then flee to from Balurghat to Malda and admit the child. The conduct of the respondent does not inspire confidence. The child would receive adequate comfort, love here, the place of stay. The frequent change of the school will not do him good. Now, let us analyze this. Now, on the face of it, this looks very good. But I think the court has made, with due respect to the honorable judges, the same error, the same mistake which the mother made. They have put the child through the process of the court with the father and made the mother look like a wrongdoer. Now, what will the child think? The child will think, my mother was wrong. And the child will unfortunately grow up with that feeling of ill will. Is this good? No, this is not good. The child, family, let's go back to Justice Mridula Bhatkar. Family, father and mother, I love you. The child is forced to make a choice because the system directs him to make a choice. So, this business of the Guardian and Wards Act in giving you the right to be declared a better parent is creating havoc in today's family structure. We have to rethink of what is going on. I think Justice in the judgment of the Supreme Court in this case, which was overturned subsequently, the court laid down a wonderful system of the principle of first strike, whichever court went first, committee of courts, and returning children back to the country from where they came. But this judgment was tweaked subsequently, and law again switched. But then in Tejaswini God, Lahari Sukhamuri, Vasudha Sethi, Rajeshwari Chandrasekhar, Rohit Tamanna, Rashneet Kaur, in all these cases, children are going back. So there is a consistent view. But now, one day, everything will change because a particular bench will think in a different way. Then children will be retained here and decisions regarding custody will be taken here. And when we get back into our system, we fall in the trap of the Guardian and Wards Act. So this system in which this complex situation comes, I think not going to not really rest. So what do we need to do? Number one, points to take home. We must have the concept of joint parenting and shared custody. One. Two, the psychology of the child in such litigation, pre litigation, post litigation, must be studied more carefully. Then, rights of the child and the child entitled to love and welfare of both parents should be the paramount consideration. Then, the role of the lawyer who's handling the child custody litigation is going to be very, very important. And I think it's time we brought in child independent lawyers through a decision of the court by practice directions or some other way. So what we really need today is we need a whip under 142. There, in a given case, the Supreme Court may consider laying down guidelines with such an enlightened Chief Justice, Dr. Chandrachud, who has such sensitivity on relating matters relating to children. I think in a given case, with his patience, with his experience, and with his maturity and wisdom, I'm sure there should be some guidelines laid down, like they were laid down in Vishakha. And it ultimately led to the enactment of the uh, sexual harassment at workplaces law. We need directions very badly. I was part of the Justice Bidal Committee where we looked at child abduction and we gave a bill. That 2 volume report hangs dust. It reached nowhere. So defining child removal, saying that removal by one parent to deprive the rights of the other is wrong, is a time is the timely need of the hour. It must find a definition. Today, when one parent removes the child out of the custody of the other parent, Section 6 says nothing is wrong because both parents are natural guardians. And that being so, there's nothing wrong. So you go back to habeas corpus. If you go to habeas corpus, sometimes the court may agree, sometimes the court may not agree. You are relegated to the Guardian and Wards Act. From the frying pan into the fire. There starts a battle, lasts 2 to 3 years, then in the High Court 2 to 3 years, then in the Supreme Court another 2 3 years. So by the time this entire process is over, parties are burnt out. A lot of money is invested, a lot of time is invested, a lot of energy is invested. Some parents lose their mental balance in the process. Why should we encourage this? Why should we not look at the Calcutta High Court judgment in a broader perspective, but with the added factor of not declaring a parent a wrongdoer? I think this is where, with due respect to the court, the judgment is not right. So don't let the child get into a trap that my father or mother is a wrongdoer and therefore should be criticized. The court should have said she acted in haste. It was not in the interest of the child. She loves the mother. Therefore, we need to strike a balance and a middle path needs to be carved out. So, with this brief scenario of the whole show, I think we should take questions because there will be a lot of people. I'm very happy that Arijit has taken the initiative to bring this judgment out. Otherwise, the judgment of the Calcutta High Court would have gone unnoticed. I think, Arijit, you should invite the king of family law in Mumbai, Mrinaliji, for her reactions. Yeah, I'm actually going to London to meet my son who is studying a law degree in London in the same college where I went 30 years ago. My daughter, guided by Nalini ma'am, she has become a sister in London. He's joined Allen and Overy, and I and my wife are going for a 10 days. But we are going to do this today. This is more important than my trip. Absolutely. But we're doing a Q&A now. Oh,
Ma'am, you're on mute.
ma'am, you are muted.
So, good evening, all of you. It's always a pleasure and a learning experience participating in webinars which are addressed by Mr. Anil Malhotra. And to a large extent, I try and attend most of them. Some of them I'm unable to attend due to other commitments. But as I said, it's a learning experience because he has a wealth of wisdom and knowledge over the period of time. And especially the one thing that we share common between the two of us are the rights of a non-custodial parent in a custody battle. I think both of us have similar views, and we both believe in the concept of joint parenting, shared parenting, and both parties to be, both the parents to be equally responsible to raise the child in a manner, assuming the parties were living together. The idea behind this is the best interest of the child. Just by using these words, the best interest of the child cannot be maintained or can be done that. The second part, which I would really like to say, is what he talked about the child independent lawyer. And yes, it's true that the Bombay Family Court, with our then principal judge who was heading, has very canvassed in a very how do I say, in a very vociferous manner that in all child custody matters we do need to have a child independent lawyer who is not a lawyer for the father or the mother, but who will be really looking into to the best interest of the child. Uh, I was part of a seminar which was organized by one of the agencies in Bombay, which was the Mumbai Judicial Academy over here at Pavai, where I spoke on the concept of child independent lawyer. And to be very honest with you, I learned about it only when I was dealing with a couple of matters in the US courts, because we had cross border issues and some custody issues were there. And that's where I learned about what is the importance and the necessity of a child independent lawyer. I truly believe that this is a concept that we need to consider, because law has to evolve. Law has to evolve according to the social changes and the structures which are there. You can't, as Mr. Malhotra in most of his webinars very, very vehemently says, you're dealing with the Guardians and Wards Act. I mean, are we serious? Are we real that we're thinking about it and thinking that is a guideline or the basis of it? Yes, it's a statute. You and I and everybody has to listen to it. The third thing that about the Calcutta judgment, and I think I agree with Mr. Malhotra's things, that wishes of the child could be considered, should be considered, because that is only to understand one aspect of it. The second part which I would like to say is, in any custody matters, orders given by the judge, when you decide the best interest of the child, do not determine the character of the parties which are before the court. When you are deciding best interest of the child, see what is positive from both ends and who weighs in a more positive manner than the rest. Because the moment you get into these accusations that the father used to be the mother, the father used to, assuming, I'm not saying that there are cases where it is true, but when you do that, you're shifting the focus from the child's best interest to the accusations and counter accusations which take place between the two parties. Does it mean that if a wife files a 498A or DV and say divorce and other such proceeding and then asks for the child custody, her case becomes strong because she's filed for these proceedings? The answer is no. The courts have to go on the touchstone of evidence and come Evidence Act and then come to a conclusion. So I think somewhere, and as I agree with Mr. Malhotra, and these are my views with utmost respect to our honorable judges of the High Court, Supreme Courts, and more importantly of the trial courts, they need to take this very seriously. They can't go as a precedent has been set up. This is a Gisa Pita kind of a stuff. Somebody has done that and we need to do that and carry forward. I'm a mother. I believe that, okay, mother is a good parent, can take care of it. But that doesn't mean a father cannot. Why do you not give that same importance to the non-custodial parent unless in extreme circumstances, there is a case of alcohol abuse or substance abuse or any of these things which are there, which surely is detrimental to the best interest of the child. But otherwise, honestly, in courts, and I'm saying this with a lot of responsibility, the fathers are looked as accused in a criminal trial. That's not what they are. They are there as a parent wanting to spend time with the child. And I always say this to my courts, and I've said this to the judges over here, that if a father or if a husband does not pay maintenance, you guys are so excited to get him arrested, to get his distress warrant, to attach his properties, to attach his income. What happens if the mother does not give the access? Why is there no penal action taken against her? Why is she not arrested? Why are there not any sort of orders which are passed that her bank statements will also be done due to the contempt they committed by the girl, by their mother? So why are these two different standards which are being utilized? Yes, it is the duty of the man to provide for his wife and the child. But is it not the duty of the custodial parent, in most cases the mother, to do the same for the child? Why is there so much of imbalance? And today I fear, I would not say fear, but I really shudder to say this. Courts are being exceedingly one-sided in their views as far as child custody matters are concerned. I'm sure you may find these words, Mr. Malhotra, permit me to say that, they are a little acidic in the way I'm putting it, but I'm really conveying the sentiments of so many fathers, non-custodial parents, who have to really go through the grind. You think they don't cry? They cry in my chambers. He's a parent. He wants to be with the child, but the courts don't think about it. So I think these kind of things are very, very important. And this awareness has to be brought. And I think at some point of time, you have to also invite judges to speak on this. The judges who are going to decide this. Because me and Mr. Malhotra are lawyers. We canvass that. We canvass through webinars. We canvass that through our matters and through other, forums that are available to us. But the judges who are going to decide these cases in any form, whether it's a trial court, high court, or a Supreme Court, you must ask them and put questions to them for them to put on their thinking cap and not go by what has been set out in particular things. As Mr. Malhotra said, in a few of the cases, the children were sent back in cross-border issues. But those are 5% of the cases. I'm talking about the remaining cases where the parties are in India. Why is there no strict sort of rule of law, if I may use the word, to ensure that the non-custodial parents get equal right? If he has to pay the money for the child, why should he not have the right to see the child? I think that's Mr. Malhotra has given a lot of wisdom to us. I don't want to add anything. I'm just sharing my experiences. Thank you so much for giving me an opportunity.
Arijit, I want to add to something what I just want to add. Now, I've dug up my brains. So, Justice Madan Lakur in Surya Vadanan did a wonderful job. He did lay down the guidelines. But then Justice Deepak Mishra in Nityanand Raghavan watered it all down. Then Justice Khanwelkar picked it all up in Lahari Sakhaburi. And Justice Deepak Gupta picked it up in the case of this Yashita Sahu. So we are back on track. But ma'am, I have a question which was raised to me in an ongoing matter. I can't discuss details. But then here is a girl child. The father gets the girl child on the weekends. The mother has the child Monday to Friday. And I suggested to the judge that this is what the father is ready to do for the girl child, provided we come to a shared parenting. And these are all the financial benefits. Look very good. And I said the mother is equal pay earner, so they are both on the same. They are highly qualified. Why should not we agree? The court tells me you must get a divorce. I said, but I don't want my child to grow up as a child from a broken marriage. I don't want that stigma. No, you have a divorce. So in chambers, some discussion takes place. We are called, and there is a plan shared parenting. Child remains with the mother. Father gets 2 hours on weekends. The the child goes to the mother. The father will have 10 days of holiday in alternate years. I discussed it with the judge. He says, did you say months? I said, no, years. Now, the court observed largely, I shouldn't be opening up, but it hit me very badly. Says, why are you talking so negatively about divorce? It's an accepted thing in society. I said, no, my client is a conventional man. He lives with his father and brother. It's a joint family. He doesn't want a stigma. But then I told the judge, why such restricted timing to the father? I said, why not overnight? Girl child cannot be given to father. What is this? Is the father going to molest his daughter? Now, when it comes to divorce, you are liberal minded. But when it comes to giving the girl child to the father, you say, no overnight custody. What is this phobia? And I am seeing in repeated cases in our court, you can meet the child in the crèche in the High Court, or you can meet the child in the children's room on the on court number 66 on the top of the floor. You bring a child to Punjab and Haryana High Court, there is at least a 20-kilometer space where there are all cars. No place to stand, no place to walk. You walk into the court building, 80 courtrooms, all black-colored people going around. Now imagine a 8-year-old or 10-year-old walking into this place. He will think, what is this place? Why should court visits take place in the custody room, in the playroom, in the child's room, or in the mediation room, or in the crèche? I have been assisting a court as an amicus. The judge says, take the child to a mall, take the child to a lobby of a 5-star hotel, give him some nice ice cream. So I think this is where, Mralini ma'am, I share your views. I have been going to Judicial Academy in Bhopal when Mr. Balram Gupta was the director of academics. I have not been invited by Justice Sai. I think they need to do a lot of family law programs. And they should bring in High Court judges, and the thinking should change. What do I see daily? I think the personal perception of a judge that the child should stay with the mother, one, Female child's custody should not be given to the father. Overnight child custody should not be given to the father if the child is a female. This needs to be cleaned out of the minds of honorable judges. You should not import your personal concept or your personal perception or your individual viewpoint into the case, and I think totally spoil the case or totally blur the identity of the child. If the child wants to go to the father, why not? The mother brings the child, he's crying because the mother is probably wound him up very badly. But then the child goes and spends few hours with the father, the child is very happy. But the court has to see this. The court must have an eye. And I think when courts deal with family law matters, they should only deal with family law matters. You should not be doing bails. You should not be doing murder appeals. You ought to have a dedicated bench in the family court, in the high court also. In,
Yes.
in England, we have the family division. Justice MacDonald is the liaison judge for the whole world in the family court. For the entire world, we have become a part of the international liaison, but we have no representative judge. I have been attending conferences on behalf of India because there is no judge. So we like we have a dedicated family court stream. We need a dedicated family law bench also for consistency of decisions, for normal views and sensitivity to the matter. Now imagine a judge who has got 50 or 60 urgent matters or 70 or 80 ordinary matters. He is going to hear bail, he's going to hear revisions, he's going to hear NDPS, and in the end we will hear miscellaneous remaining matters, family courts. And do you think by the time he comes to that matter, he has the energy, the sensitivity, or the uh, attitude to look into the case? No, absolutely no. And what do you get? A date? So I think the whole system has to be reworked. We need to rethink, and judges must go to the academy in Bhopal. They must call. I as a lawyer, used to go as a resource person. And I think in the academies, resource persons should not be judges talking to judges. Because when judges talk to judges, everybody keeps his mouth shut. But when lawyers talk to judges, I used to go there, we used to have discussions. And people used to come out and we used to exchange ideas. It was a learning process. So learning for the judiciary in the Judicial Academy is a must. We have a beautiful academy in Chandigarh. I go there very often. But this process is ongoing. We need a revolution in family law. We need to do a lot of things, and we most importantly, personal views, personal perceptions of honorable judges should not be made to reflect in cases, and the cases should be decided in the best interest of the child, the voice of the child, and the welfare of the child. This is my add-on to what ma'am says. But I think we keep speaking. Nothing happens. Yeah, 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 sure, sure. No, no hurry. Yes, Mr. Devraj Gupta, are you there?
Good evening. Am I audible?
Yeah, yeah, you're audible.
Okay, I'm so sorry. My
No, no, no,
microphone.
fine, fine, fine.
Anyways, just quickly, we are saying that the child will reside primarily with this parent, or okay, whenever we are saying that okay, this is going to be the primary custodian. Uh, do you not think that the basic purpose of joint custody shared parenting fails there? Because the moment we are saying that okay, the child will stay with this parent, and the views will have to be and the views of both the parents have to be equally respected by both the parents. Now, do you think that can work?
You see, See, listen, it's not a hard and fast rule that there should be a primary custodian. If you read the judgment in Inderbir Singh versus Amandeep Bench 2019 3 HLR 204. Now here there is no primary custodian, there is no secondary custodian. Both
Exactly.
parents are natural guardians, both have equal rights. Monday to Friday, mother exercises the rights. Saturday, Sunday, father exercises his rights. Holidays are shared, festivals are shared, and rest is to be worked out mutually. It is only in this case that the Calcutta High Court that I talked of a primary caregiver or a primary custodian, because the father had the facilities, the infrastructure, the house, the facility, and liking of the child. But then the mother can have the child on weekends. If she hasn't got time Monday to Friday because she's a working lady and she's teaching, so it can go on Saturday and Sunday. So it is not necessary that you must have a label of a primary caregiver. Just the word joint custodians and shared parenting is enough. In a given case, there may be primary or secondary, but not necessary. So, Arijit, we can move on to the next question.
Thank you so much, sir. Thanks.
Shaurya, fire off.
Can you hear me now? Hello?
Yeah, yeah.
Yeah, I'm Shaurya. Yeah, I got a judgment from Chhattisgarh High Court on 1st March 23. I got custody rights for the past 9 months, like 2 Sundays a month. Okay, but I was supposed to pick up from wife's place, but she is not handing over, saying that the child does not want to come. Okay, and it was corroborated by the High Court of Chhattisgarh on 1st March that you should be able to have the custody. But again, the same drama happened, right? I was not handed over. 2 Sundays passed, even video access, not a second the kid is coming on the video call. I've got 3 hours access for the week. But in such a case, right, the opposite party is saying like the child does not want to come, right? Then I mean this makes the whole High Court order useless, right? If the High Court order is not being entertained and like being followed, like what can I do in such a case?
See, I think the best course is to move an. Don't get into contempt petitions. You are not multiplying your litigation, spending more money, and your purpose is not to have your wife punished and sent to jail. No, that's wrong. I think you need to move an application in your case decided or pending, and tell the caller, please have the child evaluated by a psychologist, find out if the child is validated, and ask the child to sit with both the parents. Counseling should be done to a professional person.
Can we
If you have a
meet
mediation,
Rakesh? Sorry, I'm not able to hear. Rakesh? Yeah, sorry, please go ahead, sir. Yeah.
I'm saying that what you really need to do is you need to go back to the High Court and say that please call my wife through her lawyer to the court. Please let her go to the mediation cell. Please let her go and be counseled. A professional counselor should explain to her that what she is doing in tutoring the child is not good for the child. She should recondition herself. And then, after she has been, so to say, explained the consequences of what wrong she is doing, she should be asked to reform herself. And through a slow process, without any contempt issues coming up, the judge should emphatically tell her, listen, you need counseling. She needs a little whip from the court to be counseled, the child to be evaluated, and in the child to be brought in joint meeting with both the parents, maybe outside the court or maybe the mediation center in the court if you have got one, and wrong should be rectified. You have to go back to the court and you have to ask your lawyer to find ways and means. Now, this is another issue. All lawyers in the High Court have multiple matters. We don't have to give up in the High Court. So the lawyer will say, let us file it. Because that is the normal way to do it. That's not the way to do it in family cases. You have to bring the woman back before the same bench, ask the bench to reprimand her, put her on track, and follow a course. So you need to go to you need to go to a lawyer who's open to listen to you and follow a path which I think should be educative, not punitive.
Yeah. Thanks. One more question. In that 5, 6 year old son, yeah. Okay. Thank you.
Thank you very much. Firstly, sir, it is very informative and enlightening session, sir. Anil, sir. I am Tulsi Ram from Hyderabad Advocate. My question is, in the family courts, divorce, RCR, and maintenance petitions are being prejudged by the presiding officer judges. How to handle this?
Murali ma'am will answer this. You are
I am not.
you are Tulsi Das. You have Ramcharitmanas on you. I can't help you.
Sorry, can you ask me what is it you're asking?
And he is saying that RCR, divorce, maintenance are pre-decided cases, and the courts how to handle judges because they are fixed notions. Am I right, Tulsi Ramji?
Absolutely. And
No. To that extension, divorce, RCR, maintenance petitions which are filed are having much influence on the visitation rights to either of the parent. That is my question. How to get that notch from the judge's mind? Because visitation is for the best interest of the child, and divorce, RCR, maintenance are for the parties. That's the question.
That's exactly what I said in my earlier comments, which I made after Mr. Malhotra spoke. That somewhere the courts will have to keep these three things separate. Whether it's maintenance, whether it is restitution, or whether it is divorce, and the best interest of the child. What the courts get a little influence, and this is where I have a little sort of a disconnect with the courts and the way they deal with these matters, is the fact that because there are certain allegations which are made, the fear is already created in the mind of the judge with regards to the safety and the best interest of the child. Because it is very precipitously put that this is what has happened, that is what has happened, that is a good ground for a divorce. That is not a good ground to get the consent of the child or deny visitation to the other parent. Now, this as he said, in the judges need to be counseled also. I'm saying that with a lot of responsibility. The judges dealing in family matters need to be counseled and need to be told that these issues are to be handled separately. That is where the Judicial Academy comes in, and a resource person like Mr. Malhotra, who is not a judge but who can participate in those Judicial Academy discussions as a resource person, can add and bring in value to what we are all discussing this over here. That please keep the best interest of the child away from the allegation of what the wife is making in most of the cases with regards to the deciding the shared parenting part.
Ma'am, there is another issue I want to flag. That is, the DV Act goes to the Metropolitan Magistrate, and that is the most injurious order. Because it is passed without evidence, it's an ex parte order, and it awards custody, it awards maintenance, it holds a person wrong as a wrongdoer, and it outweighs the litigation in the family court. Ideally speaking, domestic violence should also be shifted to the family court, because giving it to a fledgling metropolitan magistrate who is just 24 or 25 and passes an order without realizing the consequences has a very bad impact.
So the Act itself provides under Section 26 of the Domestic Violence Act that if there are other civil proceedings going on either in civil courts or in the matrimonial courts, the DV application can be, the domestic violence application can be filed in those civil or the family court. See Section 26 of the DV Act. So there is an inbuilt provision in the Domestic Violence Act also. But to have a dramatic effect or to make a man run from one court to the other. This is some advice that the lawyers give, and I think they're part of my fraternity, so I may say that in a sympathetic manner. And that is the reason why a magistrate has to decide, even at times on the visitation matters, with utmost respect to their wisdom and their knowledge. They are not equipped to deal with this because they have no training to that effect or no experience to deal with it. But then they say, okay, the child will stay with the mother. Father, you come and see him for 2 hours in the family court premises or in the court premises. Is that a place for a child to come? This is not the right way. That is why, in fact, I'll go one step ahead and say have an independent court to decide only custody matters,
Absolutely.
which has nothing to do with divorce and these things. And there should be a format in which the petition has to be drafted. As far as you can make it in the form of a template also if you want, and deal with it in a different manner who deals with the custody, and have all the infrastructure given to the judge, a counselor, a child counselor, a psychologist, whoever he needs, and a child independent lawyer to take help of all these, I would not call them accessories, but all these other things which are there to assist the judge to come to a right decision. Don't mix it up even with the family courts right now, in the sense that the other matters are discussed.
And ma'am, another thing, the format of the guardianship petition in the Guardian and Wards Act 1890 is slightly outdated.
Absolutely.
Nobody bothers. We are living in a time when the English made a law to suit their end. We are still following it. We are talking of reform. We are talking of going forward. But look at the mental wrecks you turn parents into. And I think the bias towards men is becoming stronger and stronger.
Absolutely.
Arijit, next question. So
may I ask?
Just a minute. So Arijit, questions not relating to the topic will be paid questions. Questions related to the topic will be unpaid questions. Okay, next question, please.
So may I ask?
Yeah, we can hear you. Your name, please.
Yeah. My name is Aman, sir. So my question is like, I am having one DV case, right, where the CGM decides the school fees of the child, and when I ask for the visitation, then she says go to the family court. So what is this? In the DV, is there any provision that the judge can decide the school fees, etc.? So now when I ask for the visitation, then she says go to the family court. So what is this means?
Correct.
Yeah.
This is sorry, Mr. Malhotra, go ahead, but
No,
his concern
Monalini ma'am, this is a paid question. You take it.
so I think you are absolutely right. I mean, they can't pick and choose what they want. Either you decide all the matters or you don't. Absolutely.
So that is my related question, sir. Because judges know that there is happening parental alienation. The non-custodian parent is not given the access right, not given the visitation right. No. So my question is that let me complete my question, please. So my question is how judges can be their mentality, or there can be any change in their mentality that the child welfare is the most important, right? The non-custodial parents, they are using child as a tool, that just don't give the access to the other parent, and they are winning the cases, right? And judges are also favoring them. They have the perception that mother is a natural guardian. That is my question: how judges can be educated, or their mentality can be changed?
The one line answer is Ayushman and Shyam Padman Lettles attending very quietly should be made to do sessions only for judges, and all judges should sit in the audience, and Mrinalini ma'am and I should lecture, and we should start brainwashing them. So Shyam, your next session has to have judges only. Shyam,
Sir, what about the lawyers, sir? What about the lawyers? They should also.
So what Shyam and Shyam does metals. He has done about 290 sessions. So both of you should get together and design packages for lawyers and packages for judges. and then we will come in as paid consultants, and then we will do the instruction.
Thanks.
Can can I
Shyam, you have a question?
May I
can I go
unmute?
next? I am Gaurav. Can I go next? My question is to Mr. Anil Malhotra.
Yes, Gaurav, go on.
Yes, thank you. Thank you for this informative session. My question is, when judges decide the parenting time for the child from both the parents, whether it is okay to look at the gender of the child and then decide whether the child can stay with father overnight or not, and if the father is being asked this same question, this question, whether we I mean they seem to take some kind of a prevention measure, is it not fine that they should also ask the mother the same thing, whether mother is having a sound character, and mother is also needs to be checked whether the child can stay with mother or not? How to deal with such situations, because the gender of the child cannot define the parenting time of the child with both the parents.
Gaurav, let me answer this question straight away. I had this issue in Navtej Singh's case, where the son was born in India, the daughter was born in US and retained here. And this issue was raised that the girl child has to be with the mother. See, the Supreme Court has come out of this concept. You see Lahari Sakhamuri, Justice Khanwelkar, you see Justice Deepak Gupta in this case, Yashita Sahu. Now, what we need to do is we need to cite these judgments. In Tej Singh's case, I used to tell the judge, my wife is staying with her mother and father, but my son and daughter are staying with them. Why should not my son and daughter stay with me? If my wife wants to go to her parents, my children should come back to my parents. And I think if the judge says, you are a man, I will not give you the custody of the female child overnight, apply likewise. You are a woman, you will not get the male child's custody. Why put men in a docket and view them with suspicion in giving them overnight visitation for a girl child? Apply the principle to the woman also. You will not get custody of a boy child. Now, this thought process has crept into our system courtesy section 6 of the HMGA, which says the guardian of a child shall be the father and after him the mother, though in Gita Hariharan they are both equal. But the custody of a child less than 5 years of age shall be with the mother. So we have judicially ingrained this. We need to wash it off. It has been done in JK versus NS by Justice Sistani in the case of Navtej Singh when I argued the matter. They have said, no, this is all gone. The best interest of the child, the welfare of the child is to be seen. So we come back, Gaurav, to the point. Judges at all stages need to be updated, educated, and brought in sync with the latest views of the Supreme Court to say, please don't use gender preferences. Don't decide on gender, decide on welfare, decide on equality, decide on parity, decide on family, father and mother, I love you. So gender discrimination is absolutely wrong. It needs to be done away with. The problem is that thought process is a personal perception, is an individual view. So that individual perception or individual thought process percolates into the judicial thinking, and that becomes the order of the court. That is wrong. So that personal perception of the court or the judge is the view in the case also. I think that's where we are going wrong. Sham Sham did a session yesterday. We must get Sham to an overview.
Thank you.
He's Amitabh Bachchan of Kerala. Legal education through empowerment series.
We should
Matches.
definitely.
So you must, Shyam and Arijit, you should prepare packages for judges, packages for lawyers, and appoint me, Muralini, ma'am, and me as consultants. And you can pay us an honorarium, no problem. Or you can invite us to Kerala or Calcutta.
And for that matter, I just had one line in the last time. What we require is objective justice and not subjective justice. How to go about it? That is the only question that has to be answered for the last question, I would believe.
Muralini,
Thank you very
ma'am,
much.
last
It was a
question.
privilege.
Objective justice and subjective justice, ma'am.
Absolutely. It is very important, Sham, for you to definitely bring in judges to bring about these kind of things, that how it has to be objective and not subjective. Today, what happens is, I don't know, and I hope I'm not quoted, but I may be quoted because we are on a public platform. The judges do what is good for the press and good for the higher judiciary. They do not go into what is good in the matter. I'm so sorry to say that. It is just to get brownie points or to get whatever they may feel. I'm sure their conscience must be biting them when they go back home. Have I done the right thing? But then what looks good, what is the perception, is all that matters in today's world. The social media is there in this. And that is where my disconnect is. And this is where my cry as a lawyer is for the non-custodial.
So,
Yeah.
exactly. And Arijit, there is an editorial on the Calcutta judgment in the Indian Express today. It's mind-boggling. And Shyam, for asking that question and for getting Muralini ma'am into a wrangle of contempt, you will defend her because it was your question. No, sir, Arijit, let me point out to you. I am seeing that the number of sessions for family matters, family law matters, has been reduced drastically. All emphasis is on commercial law, arbitration law, IT law, and all these newfound laws. Family law is a poor country cousin. So you can have one or two sessions in the end because when they prepare the calendar, the number has gone on very badly. It's sad. It's very sad. It's unfortunate. Yes, yes.
I'm Sumande. I have one question. Yeah. It's 100% related to the topic. That
No,
how to judge the maturity of sir. How to judge the maturity of child. That the child views are important by the judges, honorable judges of Calcutta. How they can judge means most of the time the non-custodial parent cannot touch with the child, and other side parent brainwash the child against the non-custodial parent. So in that situation, how they judge
see,
judges?
answer that question straight away. See, Suman, you must understand that wisdom is attributed to a judge. The man who sits on that chair has maturity, wisdom, experience, and he has a judicial microscope which is inbuilt in him. It is like a CD scan. So I think the ideal way to handle this is to talk to the child in chambers privately, make him comfortable, give him a toffee, give him a chocolate, give him ice cream, talk casually. So only a sensitive judge can do this. If the judge says, no, I don't want to look at the child. So I think this evaluation can be done when the child is talked to alone. See, a mature man like Justice Sikri, in Vivek Singh versus Rumani Singh, he said, no, the child is polarized. Look at it. So you have to respect the maturity, the thought perception, and the analysis, and let the court take the view. So if not one but two judges are going that direction, they should be able to decide the voice of the child. But I think then the maturity needs to go on a higher platform of evolving a balanced formula. You don't put the noose in the neck of the mother and say she's a very bad mother. She's a wonderful mother. She's a bad wife. But that doesn't make her to be taken away. So put parents on equal platters and do equally.
Thank you, sir. Thank you very much.
See, I have certain questions. I mean,
So, all right, Arijit, let him.
see, I had just one question. I
Yeah,
mean,
yeah,
I had just one question which I have mentioned in the chat box also. That should there not be the validation of this single fatherhood concept? Like we have seen the concept of single motherhood has been legalized by our apex judicial body in certain judgments. But when you are talking about these child rights, or when you are talking about choice of the children, then should it not be considered right now? Because till now, as far as my limited knowledge is concerned, it is not recognized in India. So is it not the time for judiciary to develop a guideline just like the way how they have done in the Vishaka case? Means as long as we are not getting the legislation, when you are talking about so much activism on the part of judiciary, is it not the right time to develop a guideline which can serve the purpose of law in coming days?
ma'am.
No, Sham should answer that because he's going to get
Sham,
judges.
yes, yes, Sham.
So Sham is going to answer because he's promised us he's going to get judges and he's going to have this
Ah,
session. So Sham, please, maybe
No,
have
no,
your
I would only, I don't want to get into the troubled waters, but
Amitabh Bachchan of Letters, please answer.
no,
yes.
I will put it in this manner. If we say that we require the judiciary to step in, that means that the persons whom we elect and send it to the legislature are not good enough. So the failure lies in the person who is the voter, including you and me. Because legislature has to legislate. If it has to reflect the felt need of the society, you cannot just rest on the judiciary, which is a minuscule. I mean, they have all the capacity, everything, but what exactly the public require or the general man requires, you voice it through your vote, number one. Number two, COVID time had a very positive impact. Earlier, we never got any sitting judges or judges to these platforms because they were aloof. But they are now part of the different webinars in the length and breadth of the country, and they know when questions are put, when discussions are, with their participation happens, they are made conscious of the fact that these things are necessary. So that all gets ingrained into this, what do you call, justice dispensation machinery. So let us involve every stakeholders. Let us not just put the blame on X or Y. End of the day, we also should take the responsibility in not having proper manner in which the most important thing, we speak volumes and volumes about the next generation. This is exactly what the next generation is going to be. So unless and until you as a lawyer, someone else as some other stakeholder do the proactive role, there is no point. So I would, request both Mrinalini ma'am and Anil Malhotra to complement or contradict this by saying that can we insist the judiciary to Vaishaga and some other decisions which were harbingers for legislation later. That's a good thing. But why can't we also at the same time as a pressure group put pressure on the persons concerned, the authority concerned, the legislature to have proactive legislation which are in tune with the sentiments expressed in this platform?
The Law Commission has done that, Sham. Mr. Ajit Shah, who was
It has-
judges, has done it. No,
Since
but in this
2015, the report is gathering dust. And
Yes.
Sham, you're right. We
Yes.
should join Law Minister Riju's brigade.
So I think we all should in this responsibility.
You should not join the gang of thieves. My God, look at this statement.
Sir, I would like to, get some overview about your, concept, or looking at into the present collegium system, so that we can aware what actually is going on in the.
Sorry, sir. Sorry, this
is not something we can talk.
it's time for single malt now. Shyam, I'm coming.
No. I mean, let us not get into troubled waters.
Exactly.
Are going on.
We are not opening. Exactly. He's trying to defend the Norwegian system. That is wrong. Their system is imbalanced. They take in children into custody because it brings money. And they can't understand why children sleep with us, why we put a bindi. I have written about this. Yes, yes.
Definitely.
Yes, marriage of letters and Ayushman has to take place. And then only the offspring will be good. And Arijit, please post the video on YouTube.